Now we turn to 4 cases involving preemption. The first arising in the context of environmental law, the second involving immigration law, and then 3 cases involving product liability claims. Over the course of the last decade, various state attorneys general, dissatisfied with the policies of the Bush administration in a number of areas, sought to reassert their own preferred policies in the courts through independent legal actions. These efforts often had a decidedly partisan tone to them, but when the cases get to courts, the judiciary strips away the partisanship and looks to the merits with a more neutral eye. The results have been pretty mixed. Environmental protection was one area where states tried to assert their independence. In American Electric Power Company versus Connecticut, the Supreme Court faced one such effort, where several states, the City of New York and 3 private land trusts, joined together in 2004 to attempt to maintain federal common law nuisance claims against certain carbon dioxide emitters, specifically 4 private power companies and the Tennessee Valley Authority. Asking for a decree, they asked for a decree that would set carbon dioxide emissions levels for each defendant at an initial cap, to be further reduced annually. Well, if that claim and the request for relief sounds a lot like trying to convert the federal courts into the Environmental Protection Agency, then you will easily understand why the Supreme Court unanimously rejected the claims, holding that the Clean Air Act and the Environmental Protection Agency action the Act authorizes displaces the claims the plaintiffs sought to pursue. This result was virtually preordained once the Supreme Court held in 2007 in Massachusetts versus EPA that the Clean Air Act authorizes federal regulation of emissions of carbon dioxide and other greenhouse gases. The decision yesterday is simply the dropping of the other shoe. It is an important decision, even if an obvious one, because it plainly locates full accountability for regulating greenhouse gases with the Environmental Protection Agency. And that has the salutary consequence of concentrating advocacy efforts on the EPA and its regulatory processes instead of on the courts. In other words, if you disagree with the policy choices made by the executive branch, don't look to the courts for your salvation. Next, we turn to the controversial area of state regulations dealing with immigration. Federal immigration law, which establishes its own civil and criminal penalties for employers who knowingly employ unauthorized aliens, expressly preempts, quote, any state or local law imposing civil or criminal sanctions, other than through licensing or similar laws, upon those who employ unauthorized aliens. Arizona enacted a statute providing that the licenses of state employers that knowingly or intentionally employ unauthorized aliens may be, and in certain circumstances must be, suspended or revoked. The law also requires all state employers to use the Federal Electronic Verification System, E-Verify, to confirm that the workers they employ are legally authorized. Arizona's law was challenged on preemption grounds by the United States Chamber of Commerce and various business and civil rights organizations. In Chamber of Commerce of the United States versus Whiting, a split Supreme Court rejected the preemption claim and upheld Arizona's law. Now this case was, I think, always a long shot, because the Chamber's core argument that Arizona's statute suspending a license was preempted by the Federal Act appears on its face to be contrary to the express savings clause in the Federal Act, which says that a state can impose civil sanctions, quote, through licensing or similar laws, close quote, upon those businesses which employ unauthorized aliens. And because the Arizona Act fits easily within an express savings clause in the Federal Act, the Arizona Act is neither expressly nor impliedly preempted. To the contrary, it is expressly permitted. The dissenters' arguments in this case are pretty weak. Justice Breyer argues that the state law goes way beyond licensing to encompass things like articles of incorporation and partnership certificates, plus virtually every state law authorization for any firm, corporation, or partnership to do business in the state. Of course, as the majority observes, that is exactly the broad definition which Congress gave to the word licensing under the Administrative Procedure Act and other federal statutes. And it is the plain meaning of the term. In these circumstances, it is pretty hard to argue convincingly that Congress had a different intention when it came to the immigration statute. There are maybe a dozen other states that have similar statutes: Connecticut, Delaware, Florida, Kansas, Massachusetts, Montana, and New Hampshire. So the decision in this case is going to affect business practices around the country. California has, of course, not enacted such a statute, and is very unlikely to enact such a statute, so we won't see any impact here. Now we turn to some preemption cases involving product liability claims. Our first case, Pliva versus Mensing, involves a failure to warn claim filed against a manufacturer of a generic drug. 2 years ago, in Wyeth versus Levine, the Supreme Court faced a similar lawsuit where the plaintiff contended that a drug manufacturer had breached a state tort law duty to provide an adequate warning label. The court held in Wyeth that the lawsuit was not preempted because it was possible for the defendant, a brand name drug manufacturer, to comply with both state and federal law. In particular, FDA regs permit a brand name drug manufacturer to unilaterally strengthen its warning without FDA approval. So if a drug manufacturer learns new information identifying new risks, it can modify its warning immediately. However, in the case before the court this term, the suit was against a generic drug manufacturer, and the federal rules about generic drug warnings are different. According to the regs, and consistent with the interpretation of the regs given by the FDA itself, a generic drug manufacturer is responsible for ensuring that its warning label is the same as the brand name's warning. Under this rule, it is impossible for a generic drug manufacturer to comply with a state law requirement that would impose upon the manufacturer a duty to give a different warning than the warning given by the brand name drug manufacturer. Given these rules, the Supreme Court held that the federal regs preempted the state law tort claim because it would be impossible for a private party to comply with both state and federal requirements at the same time. Next, we turn to a design defect claim involving automobile seatbelts. In Williamson versus Mazda Motor of America, the manufacturer argued that Federal Motor Vehicle Safety Standard 208 preempted a state tort suit alleging that the manufacturer should have installed lap and shoulder belts on rear middle seats. 23 years ago, in Geyer versus American Honda Motor, the Supreme Court held that an earlier version of Standard 208 did preempt a state tort suit involving failure to install airbags. That earlier version gave manufacturers a choice between different passive restraint devices, including airbags. And the history of that earlier version showed that it was important to accomplishing the regulatory objectives to give manufacturers a choice of systems to employ. In particular, the Department of Transportation was concerned about the efficacy of airbags and their acceptability to the public at that time, and wanted to make sure manufacturers could exercise their own judgment in selecting among passive restraint systems. Permitting a state tort suit to force a single choice among the options would have frustrated that regulatory objective. Under ordinary conflict preemption principles, the state tort suit would stand as an obstacle to the accomplishment of federal objectives, and it was therefore preempted. Well, that was 23 years ago. Standard 208 was amended in 1989, and it now requires, among other things, that manufacturers install seat belts on the rear seats of passenger vehicles. They must install lap and shoulder belts on seats next to a vehicle's doors or frames, but they have a choice about what to install on rear inner seats. That is, middle seats or seats next to a minivan's aisle. There, they can install either simple lap belts or lap and shoulder belts. In Williamson versus Mazda Motor, the court reached the opposite conclusion to what it reached 23 years ago, holding that there was no preemption this time. Although the amended Standard 208 still gave manufacturers a choice, the court decided that the availability of choice was no longer a central regulatory objective, and several factors supported this conclusion. First, Standard 208 now mandated the use of specific seat belts for some seats. Second, The reason the regulation gave manufacturers a choice for the middle seats had nothing to do with safety or consumer acceptance. It had to do with the possible costs of installing a lap and shoulder seat belt in the middle seat. And the Department of Transportation had indicated that it believed manufacturers would develop less costly methods of installing those seat belts in the future. Third, and probably most important, the Department of Transportation indicated to the court that preserving manufacturer choice was not a key regulatory objective. Given these changed circumstances, the court unanimously held Standard 208 did not preempt state tort suits regarding the design choice for middle seat belts. Now, in addition to its narrow holding about seat belts, the court's reasoning is important for other preemption contexts, where a federal regulation gives an industry a choice of options for satisfying regulatory requirements. The decision in Williamson makes it clear that the identification of choices in federal regulations does not inevitably lead to a conclusion of preemption of state laws that make the choice for that particular state. Before finding preemption, courts need to examine the question of whether preserving choices is actually a key regulatory objective. Finally, the court in Brusiewicz v. Wyeth held that the National Childhood Vaccine Injury Act of 1986 does indeed preempt all design defect claims against vaccine manufacturers brought by plaintiffs seeking compensation for injury or death caused by a vaccine side effect. Now, as you probably recall, in 1986, Congress enacted in the National Childhood Vaccine Injury Act a no-fault compensation program for vaccine-related injuries. It was designed to work faster and with greater ease than the civil tort system. Under that statute, a person injured by a vaccine may file a petition for compensation in the United States Court of Federal Claims. In most cases, a special master then makes an informal adjudication within 240 days, and the court must enter a final judgment within a similarly short time frame. The petitioner can either accept the court's judgment and forego a tort suit for damages, or the petitioner may reject the judgment and seek tort relief from the manufacturer. However, Section 300AA-22B1 of Title 42 provides that, quote, no vaccine manufacturer shall be liable in a civil action for damages arising from a vaccine-related injury or death if the injury or death resulted from side effects that were unavoidable, even though the vaccine was properly prepared and was accompanied by proper directions and warnings, close quote. Given this language, the question before the court in Brusiewicz was whether the plaintiffs could bring a strict liability design defect claim, or whether they were limited to a straight negligence claim. A 6-justice majority held that the strict liability design defect claim was preempted. According to the majority, the statutory language meant that, provided there was proper manufacture and warning, any remaining side effects, including those resulting from design defects, were deemed to have been unavoidable. The decision is obviously good news for vaccine manufacturers, of which there are now only a handful. A contrary conclusion would have exposed them to liability determined by state court juries for unfortunate side effects that, though relatively rare in occurrence, sometimes create substantial injuries. The federal compensation system provides a better mechanism for compensating victims of these injuries. Well, that's it for our special report on constitutional cases decided in the United States Supreme Court's 2010-11 term. Thanks for joining us. The next and final installment of our special series will discuss the court's government law decisions. I'm your host, Clark Kelso. Have a great day in the law.